Thank you. On April 2nd, 2025, the officer was monitoring a neighborhood police radio broadcast. The officer heard a broadcast call for a theft of a department store off of East Sam Houston Parkway in Harris County, Texas. The caller gave a description of the defendant and explained the defendant had just left the store. The officer arrived in the area and found the defendant as she was described by the caller, along with a male individual with the defendant. The officer observed the defendant and the individual enter into a motor vehicle and exit the parking lot. The officer observed the motor vehicle have no front license plate and expired registration. The officer conducted a traffic stop and made contact with the defendant, and the defendant identified themselves as Kathleen O'Brien, date of birth, May 24th, 1982. The defendant stated she did not have any ID card on her person. The officer looked up the defendant by the name of date of birth on the public safety photo, and they did not resemble the defendant. The officer asked for the name and date of birth of the defendant once again, and the defendant gave the same name and date of birth. Due to the photograph not matching, the officer typically confirmed the defendant's name and date of birth with the mobile FIS that returned the actual identity of the defendant as Candace Lynn Gibbs, date of birth July 16, 1981, along with a Harris County Sheriff's Office mugshot of the defendant that matched the driver of the vehicle.
So they didn't charge her with a theft?
I don't believe so, Your Honor. Or they did not.
So what's going on with the two fraud cases that she has that shows like no bond?
Not sure.
Those cases, Lori?
No, sir. I know that she went to court on the 15th, 14th?
15th. Yes,
On the 15th on the, I received an email from her felony attorney stating that this was the only case that was holding her in and to see if I could move her up to get her out.
she said something that they weren't filed or they weren't, or something hadn't been done where.
Yeah, she said they weren't filed yet.
They're filed. I guess the judge just hasn't signed it yet.
Your Honor, it looks like there was a plea offer made originally for the endangerment of a child. And that plea offer has been made now on the fraudulent use case. That was just, I believe, discussed between the felony prosecutor and the defense attorney.
In this case, Lori, in the fraudulent use case,
Mm-hmm.
in her clutch, as they pull them over, she has the identifying credit cards, debit cards of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25 different items of other people's identifying information. You are on bond for endangering a child. You pick up 2 fraudulent use cases and now allegedly at a store doing whatever with a failure to ID. I'm not going to sit here and give you yet another PR bond. You know, at some point we have to say when, and now is that time. Your bond, literally $50 to get you out, right? But I can't sit here and continue to just perpetuate this thing over and over and over. All I want is my community to be safe, you know?
I
Right,
understand that,
so
sir.
I'm gonna find probable
In an
cause.
abusive relationship.
Don't say anything, but gotta understand that, right, I'm not gonna give her a PR bond, Lori, I'm sorry. All right. So ma'am, what we'll do now, your felony cases are set for the 30th of April. We can set you for the day after and we'll go from there. Okay, thank you, ma'am.
That's what we said.
So for anyone confused, a PR bond means she could be released without paying money, based only on her promise to return. But judges don't hand those out, like candy, especially when someone's already got multiple open cases. Do you think she deserves one? Let me know in the comments before you hear the rest.
Okay, so Mr. Sherrill, you're charged with terroristic threat. You're facing up to a year in jail and or a $4,000 fine. We have already done probable cause. I found probable cause to go forward with your case. We set a bond. He's made the bond or no?
Yes, he is.
You've made the bond,
Yes.
okay. So, I am entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Taylor as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? They're not currently together now?
No.
Okay, great. So there's just no,
So,
I don't want to talk about the case.
no, it's not. She still like communicates with like my family and my friends. Like I don't even live here, and it's events come like my best friend's wedding. I'm going to the wedding, but she's trying to come. So how do I have
Got to be careful, you know? You're not to have any contact with her, you know?
Sounds like she's using, I don't know if she knows there's a restraining or a protection
She
order.
is using. The officer was a personal friend, so that's why.
Okay, well,
So this merely says that you can't go to or near her residence, right? Where she lives, where she works. Don't have any contact with her. The problem is that there's a lot of vindictive people in this life. You know, if you go to the same place that she is and you end up bumping into each other and she says something to you, you know, it's a recipe for disaster. So you have to be very careful. If you go to this wedding and she's there, it's like a ticking time bomb. So you need to be just very careful because I don't know, you know, what kind of person she is. If she's that type of person, you got to be very careful because there are a lot of people that will call them and say, hey, this happened when it's just not true. And if it does, they issue the warrant and then it's up to you now. You pick up another charge. So just be careful, you know? All I want is just you not to have any contact with her. Don't be in possession of weapons. As long as you can do that, we're cool. I'm going to waive your appearance so you don't have to waste your time coming to court here as well. Just stay in touch with counsel and he'll tell you if and when you have to come back to court here. So you don't have to come back and forth every single court date. Just stay in contact and he'll let you know if and when you have to come back.
I appreciate it.
Do you have any questions?
I guess so.
You live in Baltimore, right? Okay. So for now, what I'm gonna have to do is I'll have you sign a reset with Victoria. We'll have you take a seat in the juror box. We'll get your bond conditions. I'll have you sign it, and after that, you're free to go. Okay?
This is where her story falls apart. She's asking for sympathy, but the court is looking at patterns. 4 open cases while already on bond. At that point, the question isn't, are you sorry? It's, can the judge trust you? And right now, it's not looking good.
Hi, Anna.
Good morning, Judge. Hi, Bruce.
Yeah.
I've got a couple to talk to you about this morning.
You do the easy ones first?
Well, whenever I have to talk to you, Judge, they're never easy.
That's not true.
Fair enough, fair. But these,
I know. Okay.
the first one is going to be Wilson Keonje. Start with the less difficult.
Okay.
Can we hear PC on this one?
Is it, you say Keontae? Keonjae? Okay, yeah, of course.
On February 6, 2025, a law enforcement officer was dispatched to an assault at Provision High School. Law enforcement officer arrived and observed 15 to 20 students fighting each other and struggling with staff members and security guards. The law enforcement officer detained a number of students. After the scene mostly calmed down, the female was struggling and fighting against male students who run out onto the floor and rejoined the fight. The law enforcement officer approached the males and told them that the female students' hands behind their back. The law enforcement officer got closer to the defendant, turned towards the law enforcement officer, put his arms up to stop the law enforcement officer's progress towards the female and said, no. The law enforcement officer grabbed the defendant's shirt and told him not to interfere or he'd be taken to jail. The defendant replied, I will, and remained in the law enforcement officer's path. The law enforcement officer handcuffed the defendant and ordered him to get on the ground and began pushing the defendant towards the ground and told him to get on the ground again. The defendant remained on his knees, pushing up against being pushed. The law enforcement officer pushed the defendant down towards the wall. The defendant pushed up, causing the law enforcement officer to fall to the ground. The defendant righted herself before continuing to struggle with the defendant to get him to the ground. I believe that's a typo. The law enforcement officer righted themselves.
So there's a fight.
Yes, Your Honor.
The officer is asking him to move, get out of the way, so he can do whatever he needs to get done, and he just refuses to get out of the way.
Yes, Your Honor.
Anna?
So it sounds like the interference is my client doing this.
He's impeding the path of where he's trying to go or what he's trying to do,
Okay.
right? I mean,
That's what I have, Your Honor.
is there a body cam on this?
It looks like we do have a significant amount of video
Have you seen the body cam? Does it show that?
I have not watched them all because it's quite a bit, Judge.
Okay.
But
I mean, remember, it's a low burden,
I understand.
probable cause, and he's, the officer says, hey, move, man, I gotta get this stuff done. And he's like, no, I'm not gonna move, I'm gonna stay here, just, I mean, I get it's just standing there, but,
Okay.
so look at the video. If you see something different, let me know.
Okay. The next one I have to talk to you about is Torrance.
Come on, Ms. Torrance.
I've spoken with the state, and so there's kind of a couple of things going on. I'm assuming you want to do the BBR first. I've spoken with the state. We are going to ask for a hearing. I'll let the state speak for themselves because
Your Honor, we do not have any toxicology back. We have blood alcohol report, but that is not the toxicology report.
Well, talking about the bond violation
Bond
report.
violation, I apologize.
It's okay.
I apologize.
I don't think the state is prepared to have the hearing today. But
I've got bond violations. The Scram device has confirmed alcohol consumption violations on 3/15/25 at 1:51 p.m., 3/23 at 7:14. Confirmation was received 3/25/25 by the analyst, and it's a third bond violation.
I understand, Judge, but
Let her go.
the rules of evidence apply at a bond hearing, and we need somebody with personal knowledge or somehow to get around that hearsay to do the hearing, and I don't think the state's prepared to do that today.
We do not have anyone here to do that today, Your Honor. I apologize.
Hey, who do we need? What Scram analyst do we need to get down here? So we can, right, so they can testify that what's in the BVR. I'm sending her now for a drug and alcohol test right now as well.
I'm going to send her for the test now.
Right now.
Okay. Okay. Have a seat, and then once they put the order in, we'll have you go over there. Okay.
She can head over for the drink.
Okay. Okay. You go over to 41 San Jacinto? Okay.
And then Anthony, do you see, who do we have that can come?
Yeah, I'm gonna
You
get
mind?
a name and.
Yeah, okay.
You want me
We'll get
to-
I'm gonna try to get it today. Okay, who else?
And then, well, so the secondary issue, on Ms. Torrance is we have gotten the alcohol report back. They sent the, blood off to get analyzed for toxicology.
Oh, Lord, did you just send the blood on?
And Judge, if,
No,
Verify when that,
this case is 233 days old and we have violation after violation. I'm not waiting anymore. She's way too much drama for me and I'm ready to set this thing for trial.
There it is denied. Even though the bond was only $50, the judge is drawing a line. This wasn't about money. It was about trust. Do you think he made the right call? Should repeat offenders still get another chance? Or is he right to shut it down here? Sound off below.
I'm not doing it anymore.
For the courts, I did email the person on that side, just got a response. Toxicology analysis still in process, pending completion, it's likely requires some time for the lab board to proceed.
Did you just send it?
No. We've been sending follow-ups. This was like a last Hail Mary attempt of, do we have it or do we not? They still have it.
Do you have other things to go on regardless?
I think we have.
No?
Spoke with defense counsel, there is, proper, there was alcohol in the system.
Well, look, it doesn't matter to me, however you guys want to do it, but to me, way too much drama. I'm setting this case for trial. That's it, because
yeah, and he has laid an offer,
I need to talk to her about the offer. If it's not moving anywhere,
Okay.
I'm setting it today.
Okay,
Way
and-
too much drama.
just to remind the court, when I was here last time, you gave them 30 days and said if they didn't have the report, that it wasn't coming.
Okay.
I understand the state has to do its job.
So can you take a look and then, take a look
Absolutely.
and then let's go. But yeah, I'm ready. Hi, Maverick.